4 items. One I've done with prohibited degrees. Second is age. There are the 4 questions there, Rose. Age, the simple and the correct solution is, Malas, that whichever of the same-sex couple is involved, that age will apply.
Sorry?
First is
Age.
prohibited degree. I've
That's
made both. Second is, Malas, age. Whichever of the same-sex couple is involved, whether it is 2 ladies or 2 men, that age will apply, be it 18 or 21. I'll come to the gradations in a minute. Give me a minute. Without having any stitching to be done on a legislative cloth. Third, now the question may arise, what about trans categories? The trans categories, my it's your lordship will hear other people are there. My own humble submission would be, in 99% trans categories, your lordship is able to slot the person as per the gender which he or she professes, says belongs to, claims, etc. Because a trans means a man's body but inclined to be a woman, or vice versa. So if your lordship were to then follow that slotting, and if the person is a man, otherwise biologically in Malasay leaning towards the feminine side, then the age of the feminine will apply, or the age of the male will apply, vice versa. The fourth point here is, the fourth point is that your lordships, will keep in mind that I am focusing on what is all these petitioners, they are focusing on the discriminatory parts of the provisions. We are not challenging every provision or interpreting every provision. We are challenging the discriminatory portions of the gendered provisions. Gender provisions which are, so we are not concerned with every provision. And certainly the government of India is not challenging any provision. So your lordship will see only our challenges or our reconciliations where necessary. Fifthly, some provisions which may not create any confusion, like 27(1)(a) of the SMA, only an example. They are peculiarly, conceptually, designedly created and applicable only to heterosexual relationship, rape. I mean, you cannot have a system which applies uniformly to every category.
No, why can't discrimination?
Rape.
Why can't it apply to a to a homosexual couple?
No, with a caveat. Well, it's a criminal offense which has been defined. I will find the shortest definition is non-consensual penile vaginal penetration. It's one simple way of putting it. Now, of course, it has been expanded after the Verma committee to mean other forms of but otherwise non-consensual penile vaginal interface. Penetrative. Now, it is true that as well as rape, apparently rape is a crime even by a woman or a man in France, as far as I know. Those are special cases. Today, your lordship's issue is, can your lordship not move forward? Possible obstructions.
And then we admit that in this case, it will apply to one kind of one kind of same-sex partner. This marriage offense,
yes,
it's a marriage offense, will apply to one kind of same-sex partner.
It is possible. I'm only saying it differently because it's a crime. According to me, it will be covered in a penetrative same-sex situation also.
No. What?
But it's a crime. A crime would have to be.
We are talking of outside of the marriage relationship. When you indulge in that, that's a matrimonial offense, entitling the other spouse.
No, it will be only if a lordship holds this marriage. The lordship will have to hold this category of unions to be a marriage first.
That's right.
Then the question will arise.
Testing.
Yes.
We're testing that if.
Yes, correct.
Then it will apply to one class of same-sex.
No, therefore, there are two ways. I mean, I can see there are two ways. One is that if your lordship holds this class to be covered, then your lordship would have 27 applying to penetrative assaults.
Then in this.
No, even for the same sex. Even for the same sex. That's the logical conclusion. Alternatively, your lordships could draw a line saying it's a criminal offense which has been defined in a heterosexual context. These are the two options. I can't say more.
Then we have three categories, really speaking. We accept the first option which you are offering, which is that A, it applies to some meal.
If it otherwise satisfies the definition.
Third, it will not apply. So there are three meanings to the same enactment.
Is from moving ahead.
No, no, it applies
These are
to the extent it applies.
There are some peculiarities.
In a heterosexual relationship,
Yes.
say there can be possibility of reading a rape into it, then how can in a homosexual relationship it not be read?
Not be ready.
Well, I'm saying in fairness, I started by saying that. In logic, no. In logic, no.
Can you lordship
There's a conundrum.
use the mic, please?
No, Manoj.
I said in a heterosexual relationship, if in case of a married
Logically,
couple,
no. Correct.
there can be rape, then how is it possible that we don't have a scenario where in a homosexual relationship, the same principle will apply, the same principle.
So, Manoj, if your lordships were to, Manoj, apply the definition of non-consensual penetrative sex, Manoj, then it would apply. Logically, that's the correct answer. With great respect.
That's the little trouble of seeing how we get into different sections, how we get into different laws,
Right.
how we get into it. So the debate would be whether we stop just short of saying, you are saying it may be empty shell, but should we stop short? I'm just thinking
No,
now.
no, Manoj,
Of
may
just-
I answer it? May I answer it?
Just saying that this is under this act, such a marriage is possible and registered. Thereafter, there may be many, many nuances which will arise.
No, no, there is.
Can we take care of all future eventualities?
No, Manoj, there is one flip side to it. There is one flip side to it. Manoj, there is a flip side to it. I'm sorry, I'm not completed yet. Manoj, this is important. I'm not completed. Manoj, marital rape is not recognized yet in this country.
That's right.
Marital rape, that's the fourth one.
It's an issue.
That's the issue pending. Today, the law is not marital rape, Manoj.
No, no.
Therefore, once your lordships were to read marriage,
There are people who are wanting us to move in that direction also.
that's
There are
Wanting
matters
us to move in a
pending.
different direction.
that's a different, Manoj,
Not
no,
matters
no,
pending.
that's a different debate.
Marital rape too.
Today, as of today, rape, there is, Manoj, it's not a recognized crime within marriage. It's maybe a ground for divorce or some cruelty. Cruelty is a better way of putting it, but now my point is different. My point is different, Manoj.
The High Court judgment-
Karnataka High Court
Karnataka
judgment
Ah,
that comes.
that's an outlier in the sense that your lordship is still debated. It's not a law of the land.
This court has not taken a view on it.
You view it,
There
yes.
was the-
There's
But I'm on a different point.
view.
If your lordships, this bench were to recognize the issue we are canvassing, within the marriage which your lordship recognizes between same-sex persons under SMA, your lordship would be recognizing, Manoj, marriage within this act.
All I said was that whatever flows from a relationship, a law which will evolve on a heterosexual relationship would equally apply to a homosexual relationship. That's the point I was trying to make.
Very well. I leave it at that.
Dr. Singhvi, the other would be, and we are open to it, we are only putting a question, would we like to go that step further to go into these nitty-gritties? Because there are several shades on the palette.
No, but this is important. The first four answer is yes, your lordships can easily iron out. Now, my point is, I am not raising them. These are, I am answering, put your lordship as an insuperable obstacle. Of your lordships to proceed. There are, but these things will happen. These will be ironed out in the goodness and fullness of time.
Noted your argument.
That's all I'm saying. I'm not raising it, Manoj.
There's a flag-
I'm in repulsion on this.
It
Stopping
can't
short
happen
of
in a-
many things is just an empty shell.
Right.
If we agree with you.
If we start.
Now, Manoj, a few words and I'm done on notice and objections. The very important part. This is very interesting, Manoj. Notice and objections. We are one of the few petitions where we have challenged it.
Will be in the
Go back to your written compiler.
an objections regime. Very interesting, Malas, and very pointed. Malas, I will not read sections 5 to 9 and thereby save time. Your Lordship knows 5 to 9 well, Malas. Just note one thing.
Which para are you reading?
Malas,
Para
it is dealt with in para 47 onwards of my note, which is page 4,
Note B.
442 of your Lordship's PDF. Now, let me oralize in point form, Malas. First, your Lordship has got, Malas, Parsi marriages, Christian marriages, so many other different kinds of marriages. No other requires a notice of prior intent to marry. I'm saying something very different. Allow me to develop this point, Malas. This is, Malas, peculiar to the SMA, that before I intend to marry you, I must declare this intent publicly and wait. Number 2, and there are all the other provisions, Your Lordship, conspicuous place and all that, Your Lordship, notice and newspaper and all that stuff. Forget that, 5 to 9. Point number 2, at the constitutional level, Malas,
This is probably a throwback from the English.
area
That you put out the bans,
completely English, Malas.
invite objections.
Well, it's reducing it almost to a sale of a house or a civil suit dispute. But anyway, that's a different issue. Let me say what I'm saying.
Look, this is a different issue. We have not filed a reply. This is tagged.
That's all right.
But
It's a
this is
legal issue.
entirely a different issue than the same-sex marriage.
It's
This
a-
applies
it's a-
to even heterosexuals.
Yes,
etc.
Yes, yes, of course.
So that
It's a
he may
pure
not,
legal issue.
No, well,
It's a pure legal
please.
issue.
so that he may not address. Well, there the arguments.
My
will be
learned friend
different.
has filed a reply. It is a constitutional issue. He has
Right.
filed a reply. And it's can I just, in the middle of
Yes,
my
yes.
argument, allow me
Yes,
to complete?
yes, Dr. Singh.
Now, Malas, what's the constitutional issue I'm making? It's a very interesting one, Malas. This part is unconstitutional because before a formal entry into what I consider a vital form of society, marriage, you are invading my privacy by directing me that I must declare my intention in public domain for objections to be invited. Malas, which married couple, Malas, he and I are marrying in the heterosexual sense. When do we have to announce first to the world that we intend to marry and we are waiting for 1 month? In the heterosexual world. Forget heterosexual, Malas, in personal marriages, Malas, under Christian Act, under Parsi Act, under other acts. Why should I say, why should I? It's my personal decisional autonomy. It's my decisional autonomy. It's the heart of my privacy. It's the heart of my privacy to decide with whom I associate, when, how, after how much time into matrimonial Malas union, be it of the same sex or the heterosexual sex. Malas, it's taken, as my Lord put it, as
Post
a
marriage, there can be a registration.
now, the next point. That's the next point.
Dr. Singhi, was this clause section there in 1872 Act, which is repealed now?
I'll just check it. I believe it was. I believe it was. 99% it was. It was. And Malas, I'm grateful because it's really a direct hangover from that Raj situation. But Malas, your Lordship are nowhere near privacy and all the 9-judge judgment and Puttu Swami and the dynamic. We have now a totally different world, Malas. We are now.
It's based on patriarchy.
I beg your
It's based on patriarchy.
Patriarchy. Now, that's now the third point. Your Lordship has in this act, as in other acts, a section 4, which says that you cannot marry if you are related, if your age is below 18, what are those conditions of marriage. My Lord has exact counterpart provisions in Christian Act and Malas Parsi Act. Conditions of marriage. My third point is, Malas, if you have conditions of marriage and you are requiring an affidavit to be filed that I satisfy all these conditions of marriage, the form is given. And if those conditions are found false, either spouse or even the outside world can challenge and get voidness or voidableness, as the case may be, then what is the purpose served with this prior objection, Malas? So now I'm on purpose, on just common sense. After 1 month, suppose I don't give a notice, I marry. After 1 month, Malas, everybody settle down. After 2 months, somebody said that these conditions are not satisfied.
No, who can? Who can approach the court then?
No, but Malas, even after, anybody can approach, Malas.
Who has
agree.
locus in a matrimonial?
Aggrieved
In a
spouse
matrimonial-
In a
only.
matrimonial, yes.
Only a spouse.
Only a
It cannot be a
spouse.
third
Spouse.
party.
Like bigger-
Correct, spouse.
Like a-
No, but I'm
only
saying,
a-
Malas, if there is a fraud, If there is a fraud of a gigantic nature today, Malas, my lord is right. For variety of things, only the spouse can.
These are
Yeah,
material, you know,
Now-
aberrations or
Yeah, yeah.
offenses which only the spouse
No
is
question.
entitled.
Now, Malas, the point is, that's correct, Malas, that's correct. That's correct.
Absolutely.
That's correct. Now, my point is, I am at the moment, what are you serving by this 5 to 9? Now comes the fourth point. I'll tell Lordship what you are serving. In actual practice, in reality, even in heterosexual marriages. Now let us forget same-sex persons. That's the fourth aspect. I have shown that this should be unconstitutional. It serves no purpose. But what is the purpose it is serving for the last several decades? It is serving, Malas, the word your Lordship, one of your Lordship just now used, Malas, patriarchy. Patriarchy includes patriarchy also.
It was created at a time when women did not have agency.
Patriarchy includes matriarchy also, Malas. There are some agonizing
Women
cases.
never had agency. Women did not have agency when these laws and these.
Malas, this is an invitation to disaster and violence. It's an invitation, come.
And if the object was to protect.
My spouse has no problem, but you
Fall
please
back
come.
on their personal law,
Yes.
then by requiring, you're virtually laying them open to invasion by society.
My
By
spouse,
collectors and district magistrates and superintendents of police.
my spouse can challenge me anytime. But no, you please from the outside come here. Your Khap Panchayat will come here. Somebody will come in different form. Malas, gunning for you. That is not possible. What is the point of all this? Malas, in the High Courts, the Lordship have sat here and there, Malas, must have handled enough habeas corpus matters, Malas, coming to your Lordships. Why do they come?
No, I think in one of the cases, I remember having said that this cannot be given. It will destroy the entire purpose of marriage.
We have the case in our written submission, we'll point this.
Delhi.
Then, Malas, the other aspect it hits is choice. Individual decisional autonomy, privacy, individual dignity. This can all be put together, Malas. These are all constitutional core values.
Of course.
Interest. What is the supervening interest? I have not been able to find out till now. There is no supervening interest here. Some very great, unknown, mysterious interest. Malas. Now, Malas, to very quickly come. Some of it has been also
Parents.
read.
198 of the
The 47 to 56 of my note is what I've just finished oralizing. Now turn to 58.
Yes.
2 minutes. Malas. At one place it is there.
Yes.
I'm sorry, 56. 47 to 55, I have finished, Malas, just now. Come to 56.
Yes.
These cases, your Lordship may see at your leisure, Malas, are important. Just note the principle.
Yes.
Intimate decisions from non-consensual public scrutiny is para 56. I hope my lords have got it.
Yes.
Yes.
And in particular, marriage is dealt with by Your Lordship Puttu Swami in that para given there. I've given all the paras 271,
Yeah.
297 specifically. Then, Malas, the right to privacy is not limited to private spaces but public spaces. It's been read, Malas, District Registrar need not be read. Navtej has been read fully, but just note the point. Then public-private divide is 58, fully covered already. That Mr. Rodgi did, Malas. Leave it, leave it. There is an important phrase I've used, Malas, in 61, right to informational self-determination. That's Puttu Swami, para 248. Puttu Swami, para 248, right to informational self-determination. This notice and objection regime is directly the heart of it, Malas. And then, Malas, decisional autonomy is 65. That's the social context, Malas, including all the invitations to disaster. Malas, 67 is an important legal principle of proportionality. Kindly give me 30 seconds on 67. This honorable court has recognized the possibility of a systematic abuse of rights infringing measures and read that into an assessment of such a measure's constitutionality under the doctrine of proportionality. This is excessive. This is completely disproportionate. What is the need for this in proportion, Malas? Your Lordships, Malas, said in Gujarat Majdoor, state action thus leaves sufficient room for abuse, thereby acting as a threat against free exercise of fundamental rights, ought to necessarily be factored in the delicate balancing act the judiciary. Directly applies, Malas. Your Lordship is inviting by this objections regime. And then, Malas, equality I've dealt with, Malas, in para 72. It's a discriminatory regime. Discriminatory because only if you choose the SMA, and if Your Lordship were to strike it down, please don't misunderstand, it's not to be struck down for same sex only, Malas. It's to be struck down per se for heterosexual and non-heterosexual. It, Malas, is the only act. Personal law acts don't have it. This is a direct Article 14, Malas. And Malas, I have given in para 80 a rather, Malas, pithy summary of proportionality. 5-pronged test, my Lord remembers. My Lord has said, I've called it out, Malas. 5-pronged test is a legitimate state object, a rational nexus between rights infringing measures. That is the suitability test, para 80, Malas. The rights measure should be least restrictive, that is the necessity test. Proportionality stricto sensu, that is balance between the extent and severity of the infringement and the object the state seeks to achieve, and sufficient safeguards against abuse. Malas, it stops at B itself. If you add C, D, E, it is completely, Malas, violative.
In my last week's judgment in Media One, I've sort of developed on the proportionality doctrine, which Justice Sikri evolved in modern day.
Modern proportionality.
And in Media One, we have tried to sort of further fine-tune it.
Least intrusive.
Least intrusive. Well, as I am done, I'm very grateful. One page at the end of some stirring words, which Your Lordship may or may not want to use. Just give it over. This is really the heart of this matter, ultimately, Malas. It's a larger matter than merely provisions. Is this correctly typed? Well, as I've given it in a bit of a hurry with some, I hope there are not some typos. Just see these 4 quotations very quickly, Malas. One is, this one, Utkarsh Shaskri na? No, ye to nahi, no. Have you given it there?
Yeah.
Malas, you Lordship will leave aside the top, Malas, what we are seeking. Just leave aside the top. Come to the quotations. Why do you add without asking me? Malas, Oberfell and Hodges, it would misunderstand these men and women to say they disrespect the idea of marriage. Their plea is that they do respect it so deeply that they seek to find its fulfillment for themselves. These are the category like us who has said that why should you be entitled to marriage? Their hope is not to be condemned to live in loneliness, excluded from one of the civilization's oldest institutions. They ask for equal dignity in the eyes of law. The Constitution grants them that right. Whereas Oscar Wilde was a declared homosexual in an era when this was something very, very different. And he died, he was actually imprisoned for it. He fell seriously ill. And then he came out and he died. He put this, fellows, an alien tears will fill for him pity's long broken urn. For his mourners will be outcast men, and outcasts always mourn. He was talking in the context of men, Malas. And then, Malas, this is lastly, I have filed these cases. There is a case called Fitzpatrick.
Yes.
The House of Lords is, Malas, the final order. The dissent is what I've quoted in the Court of Appeal. This dissent was approved by the House of Lords
I knew it.
in a reverse. I have come to a clear
Thank you,
conclusion.
Dr. Singhvi.
I'm very deeply
Thank you
obliged.
so much, Doctor.
I'm very deeply obliged.
In fact, filed a suit for defamation and lost. On this ground.
Yes. Just 1 second. Sorry, I'm reading this one.
I'm very deeply obliged.
We begin with the hearing. We begin with Mr. Raju Ramchandran. And by the end of the day, we would have completed with the submissions of Mr. Raju Ramchandran, Mr. Vishwanathan, Ms. Luthra, and Mr. Anand Grover. We take it, 4 of you would complete by the end of the day. Thank you.